Welcome back to the Unfair Housing Podcast. I'm Nicole Carrero, Managing Attorney of the Fair Housing Unit, and with me today is Vanessa Crisostomo, one of our staff attorneys.
Hi, everyone. I'm happy to be here.
Happy to have you. As a reminder, this podcast is not meant to be an exhaustive discussion of the history of housing segregation and housing discrimination, nor is it meant to create division or instill guilt, but rather to educate our listeners on what shaped our neighborhoods and our social perspectives. In doing so, we'll be better guided in efforts to improve our future and avoid repeating the mistakes of our past. We welcome your comments and lively discussion on the topics we raise, but we ask that you use kindness and consideration when making and responding to comments, and that you refrain from using threatening or violent language.
So far in Season 2, we've rounded our discussion of historical practices that led to state-sponsored segregation and unequal housing opportunities. This history culminated in the passage of the Fair Housing Act in 1968. While many people are at least somewhat familiar with the Civil Rights Act of 1964 and the Voting Rights Act of 1965, fewer are familiar with this part of civil rights era legislation, which remains the law of the land today.
Given all that we have learned about segregation in the United States, how is it that such a contentious bill was able to pass?
Few in the nation, and the record will show that very few in that room that afternoon, believed that fair housing would in our time become the unchallenged law of this land. And indeed, this bill has had a long and stormy trip.
You just heard President Johnson's remarks following the passage of the Fair Housing Act, and he was not at all exaggerating. Congress would consider the bill on a regular basis from 1966 to 1967, but it could not garner enough support to pass. Let's hear a bit more from President Johnson about its origins.
On an April afternoon in the year 1966, I asked a distinguished group of citizens that were interested in human rights to meet me in the cabinet room in the White House. In their presence that afternoon, I signed a message to the Congress. That message called for the enactment, and I quote, of the first effective federal law against discrimination in the sale and the rental of housing in the United States of America.
The meeting that President Johnson references included Dr. Martin Luther King Jr. The two men had a personal relationship and spoke often about civil rights and how to bring about racial equality. President Johnson expressed support for Dr. King's ideas from the outset of his presidency. Let's listen.
Well, this is mighty fine. I think it's so imperative. I think one of the great tributes that we can pay in memory of President Kennedy is to try to enact some of the great progressive policies that he sought to initiate.
Well, I'm going to support them all, and you can count on that, and I'm going to do my best to get other men to do likewise, and I'll have to have y'all's help. I never needed more than I do now.
Well, you know you have it, and just feel free to call on us for anything.
Following that conversation in 1963, President Johnson went on to sign the Civil Rights Act of 1964 and the Voting Rights Act of 1965. However, the Fair Housing Act failed to pass until the unthinkable happened.
I have some very sad news for all of you, and I think sad news for all of our fellow citizens and people who love peace all over the world. And that is that Martin Luther King was shot and was killed tonight in Memphis, Tennessee.
The day after Dr. King's assassination, Senator Walter Mondale, one of the bill's sponsors, said, "The foremost proponent of a nonviolent confrontation between the races is dead. His generosity to the white man, his belief in the basic goodwill of all men, and his dramatic nonviolent action enabled him to speak to both races." Senator Mondale joined Republican Edward Brooke of Massachusetts, the Senate's only black member, in 1966 to sponsor an amendment to the bill that prohibited discrimination in the sale and rental of private housing. In reflecting on being asked to sponsor the bill, Mondale said, "I was young and thought I could do anything. I was a bit flattered that I'd get a bill that was so important." It was Mondale's first term in Congress. Perhaps unbeknownst to him then was that President Johnson couldn't find another willing sponsor. So controversial was the topic of desegregation. Following Dr. King's death, Mondale urged legislators, "In the days ahead, we must act to fulfill King's dream." And so, just 1 week after the death of Dr. King, Congress passed the Civil Rights Act of 1968, also known as the Fair Housing Act. The act initially included 4 protected classes: race, color, religion, and national origin. In 1974, sex was added as a protected class, and in 1988, President Reagan signed into law the addition of 2 more protected classes: disability and familial status.
Effective enforcement of our nation's fair housing laws is also essential to ensuring equal opportunity. In the year ahead, we'll work to strengthen enforcement of fair housing laws for all Americans.
A remarkable time in American history led to remarkable legislation that remains the law of the land. But just what kind of rights do we have under the Fair Housing Act? When we come back, we'll break down Fair Housing 101, including the protected classes, intentional discrimination, and disparate impact discrimination.
Hey everyone, Vanessa here. We hope you're enjoying the Unfair Housing podcast. Thank you for joining us, and remember, if you or someone you know is experiencing housing discrimination, or if you would like to schedule a fair housing training, contact our Fair Housing Unit at 800-875-8785. To see if you qualify for other legal assistance, contact the CLS helpline at 800-405-1417. And don't forget, give us a like, follow, and share the series with your friends and family. You can follow CLS on Instagram and Facebook. You can also visit our website at legalaccessforall.org.
Welcome back. Now that we've had a chance to discuss the passage of the Fair Housing Act and its amendments, let's dive into the protected classes and prohibited forms of discrimination. Vanessa, can you remind us of what the 7 protected classes are?
Sure. The 7 federally protected classes are race, color, national origin, religion, sex, familial status, and disability. Race refers to whether a person is white, Black, Asian, American Indian, or Alaska Native, Pacific Islander, or Native Hawaiian, while color refers to the visible color of a person's skin.
Interesting. What about national origin? Does that just refer to the country where someone was born?
It does, but it also includes where someone's ancestors were born, as well as ethnicity, culture, and language.
So, if someone has limited English proficiency, they might be protected based on national origin?
That's right.
So, it sounds like the Department of Housing and Urban Development, aka HUD, as well as courts, have offered some guidance on what these protected classes may encompass. What about the remaining protected classes? Anything of note?
Definitely. Religious discrimination includes any aspect of a person's religious observance or practice, as well as treating someone differently because that person is married to or associates with an individual of a particular religion. Familial status is another one that may be less intuitive for people.
Right. Familial status refers not only to discrimination against households with 1 or more people under 18, but also foster and adoptive families, people in the process of becoming foster or adoptive parents, and households in the process of acquiring legal custody of a child under the age of 18. A common fact pattern we see in familial status cases involves restrictions on minors in common areas, for example.
That's right. We will talk about the Concord Court at Creative Village case in a moment as an example of intentional discrimination.
Can't wait to hear more about that case. The only protected classes we haven't touched on are disability and sex. Anything of note there?
There is a lot we could say when it comes to disability protections under the Fair Housing Act. But for today, I would note that disability refers to a physical or mental impairment that substantially limits 1 or more major life activities. Major life activities include things like caring for yourself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working.
So there isn't a list of certain diagnoses to qualify as a person with a disability under the Act.
Exactly. And when it comes to sex, that would include sexual harassment and potentially survivors of domestic violence under a disparate impact theory, which we'll get into later.
Yes, we'll touch on the Butler versus Sundo Capital LLC case in just a bit. When it comes to sex discrimination, we should also mention Wetzel versus Glen St. Andrew Living Community LLC and Bostock versus City of Clayton County, Georgia, because they speak to other protections that may fall under sex discrimination. In Wetzel, the Seventh Circuit held that discrimination based on sexual orientation is discrimination based on sex under the Fair Housing Act. In Bostock, the Supreme Court found that under Title VII, sex discrimination includes sexual orientation and gender identity in the employment discrimination context. Given their similar language and the fact that both are parts of civil rights laws, Title VII and the Fair Housing Act are given like construction and application by courts. So, Vanessa, before we move on from describing the protected classes, I notice you said federally protected classes. That's an important distinction, right?
Correct. Municipalities may offer additional protections. For example, Orange County, Florida includes age discrimination, lawful source of income, domestic violence survivor status, and marital status in the municipal code.
So, practitioners should check county and city ordinances for additional protections?
Absolutely. Cities and counties may have additional protections, so it's a good idea to check your local and state fair housing laws.
Got it. So, Vanessa, it's sometimes said that there are generally two forms of discrimination: intentional discrimination and disparate impact. Can you tell us, what does intentional discrimination look like?
I think we're all familiar with the term discrimination, but what does intentional discrimination mean under the Fair Housing Act? And just as important, what does it look like? As we just explained, there are protected characteristics under the Fair Housing Act that make it illegal for a member of a protected class to be treated differently by a housing provider. Under Chapter 42 of the United States Code, Section 3604, it is unlawful to discriminate against any person in the terms, conditions, or privileges of a sale or rental of a dwelling because of race, color, religion, sex, familial status, national origin, or disability.
Those are quite a few groups. Where do we start our discussion?
Let's start with a recent case from right here in Florida. Miss Watts, an African-American woman, was living in West Palm Beach, Florida, with her 2 children and a service dog. She brought a claim against her HOA alleging violation of the Fair Housing Act's anti-discrimination provision. Watts became an HOA board member, and during the HOA meetings, board members would make disparaging comments about people of color, using terms like monkeys and bye Felicia. When she proposed reopening the basketball courts, the board members denied the proposal, citing it attracted too many people of color to the courts.
So it sounds like the HOA was engaging in conduct that, on its face, was discriminatory.
Right. Now, keep in mind that Watts was the only African-American person who attended the board meetings. After she made a complaint, the board denied her membership without any notice. She also alleged that the HOA selectively enforced the HOA rules pertaining to parking, pets, and yard sales. She even gave up her service dog because of the escalated tensions with the HOA. Watts also alleged that the discrimination extended to her guests as well. One of her guests was falsely accused of trespassing, so her friends stopped coming to her home for fear of being falsely accused and arrested. She ultimately moved out of her home.
And what did the court say?
The U.S. Court of Appeals for the 11th Circuit held that Watts satisfied her burden for maintaining a discrimination claim under the Fair Housing Act.
And the 11th Circuit, of course, is controlling precedent here in Florida. So the Watts case is a good example of intentional race discrimination. What are some examples of intentional discrimination when it comes to, say, familial status?
Let's take a look at a case out of Orlando, Florida, that demonstrates what discrimination based on familial status looks like. 10 families who lived in an apartment community with their children alleged that their children did not have equal access to their homes. There were a number of concerns, but there was one specific policy that created much hardship for these families. Management wouldn't issue key fobs to teenage residents, and this made it really difficult for children whose parents worked.
So that policy you identified, which on its face treated families differently than other residents, resulted in the children having no way of gaining access to their homes?
That's exactly right. We're all familiar with the term latchkey kid, but here the children had no house key to enter their own homes. These children would often be left waiting outside of the property. One tenant even declined a job opportunity because her children had no way of gaining entry into their apartment after school. There was another policy that prohibited the children from common areas and amenities unless supervised by an adult tenant. This led to staff members threatening children with the police. And in at least one instance, the children were told that their families could be evicted because they were using the common areas. This created an environment where teenage residents were essentially confined to their apartments.
Wow, what ended up happening?
Well, the families filed a complaint with HUD. Property management agreed to pay $265,000 to the families who were harmed. HUD commended the Department of Justice for enforcing the act in this case, stating, "Families with children should not be denied the full use and enjoyment of their home because of discrimination." So those are a couple of recent examples of intentional discrimination cases. We should also talk about the most common bases of fair housing complaints. Nicole, can you guess what that is?
I'm kind of cheating because I cite this statistic all the time. It's disability, right?
Yep, that's right. According to the most recent trends report from the National Fair Housing Alliance, 52.61% of fair housing complaints were disability related.
I've noticed during outreach events, people are always surprised by that figure, but disability is consistently the lion's share of fair housing complaints.
Right. We see this a lot in our work. So for this discussion, let's take a look at a case out of Altamont Springs, Florida, that went up to the 11th Circuit Court of Appeals. In 2008, a gentleman named Mr. Bogata, who had served in the U.S. Air Force, brought a dog to live with him at his condominium. The dog helped him manage his post-traumatic stress disorder that he had developed during his military service. After having the dog in his home for 2 years, the association demanded that he remove the dog from the property, claiming the dog exceeded the weight limit. Mr. Bogata provided an initial letter from his treating psychiatrist explaining that the dog was an emotional support animal. The association responded by asking for more details about the dog, like, "What specific training has your dog received?" And explain why a smaller dog would not sufficiently provide an equal opportunity to enjoy the unit. 7 months and 3 additional letters of support later, Mr. Bogata still had no answer from the association. Finally, in December, Mr. Bogata filed a HUD complaint, alleging that the association's conduct amounted to a failure to provide a reasonable accommodation in violation of the Fair Housing Act.
7 months and 3 support letters. That's a long time to wait on a response and a lot of information to provide. So what ended up happening?
The case went to court, and the court essentially saw this 7-month delay as a constructive denial. The case was first heard by the trial court, and it ruled in favor of Mr. Bogata on all issues. The association appealed, arguing that their responses reflected an attempt at meaningful review. The appeals court affirmed the trial court and said that the failure to make a timely determination after meaningful review amounts to constructive denial of a requested accommodation. They further held that meaningful review does not entitle a defendant to extraneous information.
That is something we see a lot. Housing providers requesting information beyond the permissible scope of the Fair Housing Act and not responding in a timely way. It's unfortunate that intentional discrimination persists to this day.
It is, but that's why the Fair Housing Act exists, and why we owe so much to our predecessors who saw its passage. And it doesn't just prohibit intentional discrimination, it also addresses rules that have a discriminatory effect, what courts call disparate impact. Nicole, can you describe what disparate impact means for our listeners?
Sure. Disparate impact, sometimes called discriminatory effect, refers to a neutral policy or procedure that negatively impacts members of a protected class. In other words, a policy on its face does not single out individuals by race, color, or any other protected characteristic, but when it's enforced, it causes an adverse effect. So discriminatory intent is not part of the analysis. The Supreme Court, in deciding whether the Fair Housing Act includes disparate impact, held that unlike an intentional discrimination case, where the plaintiff must show discriminatory intent or motive, in a disparate impact case, a plaintiff must show that the challenged policy or practice has a, quote, disproportionately adverse effect on minorities and is otherwise unjustified by a legitimate rationale.
That sounds tough to show. Can you give us some examples?
Absolutely. And you're right. This may be harder for people to detect, so I will give you a couple of examples. But first, I want to explain that courts use a 3-step process for evaluating the sufficiency of disparate impact claims. First, the plaintiff must show that the challenged practice or policy caused or will predictably cause a discriminatory effect. Plaintiffs can support this showing with statistical evidence. The challenged practice or policy cannot just be a one-time decision by a housing provider. Once that's established, that burden will then shift to the defendant, the housing provider, to show a substantial, legitimate, non-governmental interest. If that is accomplished, then the plaintiff may win by demonstrating that whatever the housing provider's stated interest is could, quote, be served by another practice that has a less discriminatory effect.
Where is that quote from?
That is a regulation that was issued by HUD in 2013. You can find it in the Code of Federal Regulations.
Gotta love the regs. So, that is the test on paper. How does that 3-step analysis play out in a real case?
Let's look at Reyes versus Waples Mobile Home Park Limited Partnership, a Fourth Circuit case dealing with discrimination based on national origin. In that case, 4 Latino couples brought suit challenging a park policy requiring documentation that proved legal status in the United States in order to renew their leases. In their complaint, the plaintiffs alleged that the policy was disproportionately ousting Hispanic or Latino families from their homes and denying them one of the only affordable housing options in Fairfax County, Virginia. To support their claim, plaintiffs included statistical evidence to demonstrate that the policy would negatively affect the undocumented immigrant population, and so by extension, the Latino population.
So, part 1 of the test was satisfied. The plaintiffs identified a policy that was causing or would predictably cause a discriminatory effect.
Correct.
So, then the burden shifted to defendants to show a legitimate interest in the policy. Were they able to do that?
They attempted to as the case went on. The park claimed they wanted to avoid criminal harboring liability and cited a criminal anti-harboring statute, which can be a legitimate business interest under the Fair Housing Act. But the appellate court rejected that argument based on the insufficiency of evidence. Judge Wilkinson, who wrote the opinion, said that the anti-harboring statute does not plausibly put the park at risk for prosecution simply for leasing to families with undocumented immigrants. He also said that if the park were at risk for prosecution under the anti-harboring statute, it would have a difficult time explaining to a prosecutor why, instead of evicting known undocumented immigrants, it opted to implement a surcharge instead.
That's very interesting. So housing providers at the other end of disparate impact claims should be aware that in this burden-shifting framework, courts will scrutinize their stated interests. And if housing providers can show a legitimate business interest, the plaintiff would then have to demonstrate a less discriminatory alternative.
Exactly. And just to give you a sense of how long these cases can last, the Reyes case was initially filed in 2016. It was settled just weeks ago in the beginning of April 2025. There is one other disparate impact case I want to highlight briefly, Butler versus Sundo Capital LLC, out of the Western District of Pennsylvania. It's a sex discrimination case. The plaintiff was a survivor of domestic violence, and the court denied a motion to dismiss because she was able to show a rent acceleration clause would have a disparate impact on survivors of domestic violence and, by extension, women.
For those who don't know, what is a rent acceleration clause?
Rent acceleration clauses in lease agreements give a landlord the right to demand immediate payment of all rent due for the rest of the lease term if the tenant defaults.
I can imagine how survivors of domestic violence who need to relocate would have to face that issue. That could potentially amount to a hefty sum. So when it comes to domestic violence survivors, is this a widely accepted theory of disparate impact liability?
It is definitely an issue to watch because different trial courts have different opinions on it. I'm eager to see some appellate authority on it.
Understood. Thank you for that disparate impact crash course.
You are so welcome. As we've heard throughout the show, discriminatory practices like blockbusting, sneering, and redlining, to name a few, cause segregation and housing inequality throughout the United States. That legacy was finally addressed on a fateful day in April 1968, but the work continues. We hope you've learned the basics of how the Fair Housing Act works and what your rights are under the law. Join us next time when we'll hear from a very special guest, John Relman, founding partner of Relman Colfax, a leading civil rights firm known for their groundbreaking work in fair housing.
Thanks for joining us this week. We hope you enjoyed today's episode. If so, give us a like and don't forget to follow us on Facebook and Instagram. Subscribe to the podcast so you always know when new episodes are released. Feel free to leave us a comment and share our information with your friends and family. We look forward to having you back next time. We'll see you then.